This is a small attempt to help legal students or any other students who are studying intellectual property laws prepare for the future. I will try and answer some of the critical questions in each session, which hopefully will be helpful for study purpose. So today we will deal with the question, what do you understand by the term patent? What are the legislative provisions regarding patents? What are the principles underlying the patent law? So, meaning of the term patent. It means a grant of some privilege, property or authority made by the government or the sovereign of the country to one or more individuals. The instrument by which such grant is made is known as patent. The term patent acquired statutory meaning in India when the Patents Act 1970 was promulgated. Patent under the Act is grant from the government to the inventor for a limited period of time the exclusive right to make use, exercise and lend his invention. It conveys to the inventor substantive rights and secures to him the valuable monetary right which he can enforce for his own advantage, either by using it himself or by conveying the privileges to others. He receives something tangible, something which has present existing value, which protects him from some competition and is the source of gain and profit. After the expiry of the period of which exclusive right is granted to the inventor, the invention can be put to use by any person other than the one to whom a patent had been granted. The person to whom a patent is granted is called patentee. Now the legislative provisions relating to patents or regulating patents. The Indian Patents Act 1970 and the Patent Rules 1972 regulate the grant, the operative period, the revocation and infringement of the patents. Principles underlying the patent law in India. So the principles upon which Indian patent law is based are enumerated here. To be patentable, the invention must be new and useful. It also must be non-obvious to a person possessed of average skill in the art. What is obvious to a person skilled in the art cannot be patented. For instance, an invention in carpentry may be non-obvious to a layman, but it may be obvious to a carpenter of average skill. Such obvious invention would not be patentable. So, the element of novelty, newness in an invention is dependent upon the state of prior art, that is, the existing knowledge and similar inventions already known in the particular field. There would be no novelty if there has been prior publication and prior use of an identical invention. Usefulness. The invention, besides being new and non-obvious, must also be useful. An invention which is new and also non-obvious but cannot be put to any beneficial use of the mankind cannot be patented. However, not so useful inventions are protected in some countries as utility models, but that concept is not statutorily recognized in India. Non-obviousness. The invention must be non-obvious to a person skilled in the art to which the invention relates. However, there are some exceptions. Some invention, in spite of being new, non-obvious and useful, cannot be patented under the Act. They are those inventions which are injurious to public health or violate public morality or public interest, which would be a new method of agriculture or horticulture. Non-patentable invention, in order to have a more widespread benefit of such invention rather than concentrating the commercial gain of such invention in the hands of the inventor alone, or it is a process of treatment of human beings, animals, or plants and hence cannot be patented. So just imagine the consequences of such an invented process of treatment patented. A patent residing in Shimla, rather a patient here residing in Shimla needing treatment invented and patented by the Bombay doctor would have to go to that doctor in Bombay who invented the process of treatment, say of muscular spasms. So such a patent over a process of treatment, if granted, would run counter to public purpose which every legislative and executive act has to serve. Next, the invention must be disclosed fully. While the Act grants the exclusive right to the inventor to exploit his invention for commercial gain for a specific period of time, it also imposes on him the duty of fully disclosing the invention in the complete specification so as to facilitate anyone from the public working the invention once the period of protection expires. The full disclosure of the patent is mandatory. If an inventor fails to disclose the invention fully, the patent will not be granted. The validity of such patent, even if granted, can be contested by an opposing party. The patent can be revoked on such contest succeeding. The grant of patent confers the exclusive right of use on the patentee for commercial gain, but the Act recognizes that the central government may use any invention even without the payment of royalty to the inventor. For instance, the central government may use an invention being a medicine or drug for the purpose of distribution in any dispensary, hospital or other medical institution maintained by or on behalf of the government. The idea is that the invention can be put to use for general public benefit by the government in certain circumstances when the patentee would have to forego his commercial gain in the general public interest. Some restricted use of a patented invention is permissible under the law. The essence of a patent is conferring of the exclusive right on the patentee. Yet, some restricted use of a patented invention by a person other than the patentee is permissible under the law. For instance, use of a patented invention is permissible for research or experimental purpose or for imparting knowledge on instructions to pupils. Thanks for watching. I hope you find the content useful and helpful. Let me know if you have any questions or feedback. So until next time, goodbye.